Hi, I'm Andy Harris, an attorney with Maddin Hauser. Today, I'm breaking down one of the most important but often overlooked parts of the eviction and litigation process, the notice of default. If you're a commercial landlord or tenant, the eviction or litigation process often commences with a notice. And while subsequent parts of landlord-tenant cases can be intricate, the first step, the notice step, is worthy of examination in and of itself. First, what are we talking about when we reference a notice of default? Simply, it is a written notice sent by one party, usually the landlord, telling the other party that they violated the lease in some way. Such breaches can include failing to pay rent, not maintaining insurance, improperly using the premises, or failing to fulfill a maintenance obligation. One of the main purposes of a notice provision is to give the allegedly breaching party a chance to cure the problem and fix the issue before more serious action is taken, such as eviction or a lawsuit. Under Michigan law and in most commercial leases, the time period for a notice of default can vary, and this difference can significantly impact how quickly a landlord can enforce its rights. A 7-day notice is typically used for monetary defaults, such as unpaid rent. It gives the tenant a short window, usually 7 days from the date of service of the notice, to pay the outstanding amount or face an eviction lawsuit. These shorter notices usually deal only with non-payment of rent. A 30-day notice is usually required for non-monetary defaults, things like maintenance failures, unauthorized alterations, or breach of use clauses. These issues often take longer to resolve, so tenants receive a longer period to fix these types of problems. Landlords can also run into trouble if they accept rent payments after service of the 30-day notice. In some cases, leases even require the tenant to begin curing the problem within 30 days, but allow a longer period if the tenant can't reasonably be completed within that time. In Michigan commercial lease litigation, the timing and content of the notice can determine whether a landlord gets the relief they seek or whether a judge will send them back to square one. That's because a landlord who files an eviction or breach of lease lawsuit without giving the proper notice or without allowing the tenant the full cure period promised in the lease faces a dismissal of their case by the judge. Courts may strictly enforce notice and cure provisions in leases as a condition precedent to eviction. In other words, if the landlord didn't follow the notice requirements exactly, they may lose their right to enforce the default, even if the tenant was clearly in breach and the case otherwise would have been a slam dunk. Bottom line, the difference between a 7-day and a 30-day notice isn't just procedural, it can determine who wins and loses in commercial lease litigation. Given the critical importance of notice provisions and how they impact a landlord's ability to obtain relief when a tenant defaults, landlords should work closely with their counsel to draft suitable notice and default language in their leases. If a default occurs, landlords should again consult with their attorney to make sure that any notice matches the required form, delivery method, and time period. If you're a landlord seeking to enforce a default, please contact me to discuss so you can position yourself to obtain the relief you need and avoid costly errors and delays.